The Supreme Court today declining to hear two separate cases out of California that touch on the scope of the Second Amendment. In deciding not to hear those cases, the Supreme Court let stand a lower court's ruling upholding the state's 10-day waiting period on gun purchases and another that imposes fees on firearms transactions to fund background checks. Well, it is a Supreme Court case being watched by both the business and political communities, a dispute testing the ability of public unions to force employees to pay dues even if they say they want nothing to do with the union's political efforts. It could also test the burgeoning power of President Trump's first appointee to the Supreme Court. Mark Janus has worked for years as an Illinois state employee and pays about $550 annually to AFSCME, the powerful public sector labor union.
I work for Healthcare and Family Services, and I'm forced to pay money to a union that then supports political causes that I don't agree with.
Janus says he doesn't want to destroy the unions and thinks workers do have a right to organize. But he opposes having to pay for a union's lobbying efforts, especially at a time when Illinois is facing a crippling financial crisis.
Well, in many states, workers are forced to give money to a union whether they want to or not. And when they do that, they're funding union politics. And not all workers want to support that union agenda just because they've taken a government job.
Now Janus's free speech fight is before the U.S. Supreme Court. The justices are being asked to overturn a 4-decades-old ruling over so-called fair share fees, which allow states to require government employees to pay money supporting collective bargaining and other union activities, whether they join the union or not. Labor leaders oppose so-called free riding by workers like Janus and say they have a legal duty to advocate for all employees.
Everybody deserves the power to win better wages and benefits and retirement security, whether you're in a union or you're not in a union. That's how we build an economy that works for everyone.
The Supreme Court deadlocked on the issue 2 years ago, just after Justice Antonin Scalia died suddenly. And his replacement, chosen by President Trump, is now expected to be the deciding vote this time around. Justice Neil Gorsuch faced strong labor union opposition at his confirmation hearings last spring, but told senators his record backing workers is solid.
If we're going to pick and choose cases out of 2,700, I can point you to so many in which I have found for the plaintiff in an employment action or affirmed a finding of an agency of some sort for a worker.
Experts say the legal and political stakes here could well determine the viability of the union movement in the U.S.
Certainly, opponents of unions see this case as something that they hope will substantially diminish the power of labor. But make no mistake, this case is a very serious potential blow to the union movement.
Union membership nationwide is now less than 11% of the workforce, but about a third of government employees are members. A Supreme Court ruling is expected by late June.